Well, to get some legal analysis on this, I'm joined by Dr. Llewelyn Curlewis. He's from the University of Pretoria. Thank you very much, Doctor, for joining us. This is a right mess. I mean, two different dockets pertaining to the same case. It seems when it comes to the prosecuting authority, the left hand simply doesn't know what the right hand is doing.
Yes, definitely. I do agree with the sentiments raised by yourself as well as Christelle Lewis. Obviously, the state must rise to the occasion and answer a couple of simple questions. One of them being, why did they come to two different conclusions, the prosecuting authority in the Gauteng North Division versus the decision made by the Gauteng South Division to charge two separate sets of accused? Obviously, they are entitled to explanation. And that is a simple answer to be expected from the state and the prosecuting authority. What is of concern is the fact that they've only closed the existence of docket 375, the so-called second docket this morning, which boils down to nothing but, if you ask me, trial by ambush for the defense. And rightly so, the accused number 5's defense advocate posed this problem to the court and seeked an explanation and also time to peruse properly the contents of that docket in order to scrutinize the contents and then compare the various statements that was contained in the two different dockets. So I do tend to agree with the sentiments raised by the defense legal team.
Yeah. Given what you've just said, I mean, and given the seriousness of the disruptions now to proceedings, is the MPA compelled to give an answer before Monday? Because if it doesn't, obviously it means that it's going to create an impasse for proceedings.
I do agree with that answer. The bottom line is the judge will probably either expect the state to give an explanation, a reasonable explanation. Alternatively, the state must face the consequences of their decision not to answer that question, which means that a possible negative inference could probably be made from that decision then not to disclose the total contents of the second docket. Alternatively, to properly give an explanation for the fact that they only recently gave that docket to the defense. So definitely, I do think there's going to be a negative inference made from this incident, and it will count in favor of the defense, definitely.
Yeah. If there is a negative inference, as you say, what does that then mean for the current case that we're observing? Could it just be dismissed?
Well, no, I don't think it will necessarily automatically be dismissed. Remember, a court case is like a puzzle. There's a lot of evidence that must be taken into consideration in conjunction with one another, ultimately to make a decision. In the case of a criminal case, beyond reasonable doubt. So this is one piece of puzzle that will not favor the state, obviously.
Yeah.
And ultimately, they bear the onus of proof. So where there's doubt in the mind of the court, then ultimately the accused will get the benefit of the doubt. That is what our Constitution depicts, and this is how the criminal law works. So unless the state gets their house in order, I do foresee, in addition to all the other problems that we've seen up to now, the issues relating to the forensics, the so-called expertise of the first state witness, for example, all those things seems to be shortcomings in the state's case, and ultimately that can result in an acquittal for the defence.
Yeah, indeed. Now, we understand that Sergeant Mosia has deposed an affidavit for both cases, basically. But given that he has been giving evidence, presumably it doesn't really matter, because whether he's giving evidence in this particular relating to this particular docket or the other one, his evidence would not be materially different, because it's about how he investigated the scene rather than who's accused of the murder.
I do agree with that comment. However, there's always the possibility that that could be, and I'm not saying that there might be a discrepancy in the two statements that he made. And if that's the scenario, then obviously it might reflect on his credibility as a witness. But other than that, I do agree with your argument and what you said, your statement.
Dr. Llewelyn Curlewis, thank you very much, sir, for having joined us. He's a legal expert and he's from the University of Pretoria.